Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on this week's discussion. On this week's discussion, we're exploring the topic of statistics, trends, and disturbing facts in California's workers' compensation system. And you know, it's not easy being a qualified medical evaluator. We're called upon to make medical determinations, most of the time without full access to all of the facts necessary to make accurate medical determinations to accurately resolve disputed issues. And I'm sure you will agree with me that this is the case. And in order to illustrate this, let me just give a very brief example of this before we get into the topics of today's discussion. I'm looking at a cover letter just received for an evaluation that's coming up next week. And this is a cover letter from perhaps the largest workers' compensation administrator in the entire state of California. So I'm sure you know who that is. And the cover letter states that you are being asked to examine the applicant because there is a dispute with the findings of the primary treating physician's determination regarding the following. It says, number 1, permanent stationary status. Number 2, the extent and scope of medical treatment. Number 3, the level of permanent disability, and a couple of other bullet points as well. And so from these bullet points, we can tell that this is an evaluation that's ordered under Labor Code 4061, where the primary treating physician has rendered opinions and conclusions, and now there's a dispute regarding those, and we, as qualified medical evaluators, are being called in to resolve that dispute. So in the claims administrator's cover letter, she says, please comment on the disputed findings of the treating physician. Do you agree or disagree with the treating physician's findings? Please be specific regarding the basis of your findings. Well, there's nothing unusual about this as a cover letter. What's unusual in this particular case is that the claims administrator includes no medical records. There are no medical records from the primary treating physician upon which to comment. She says, please comment on the disputed findings. There's no findings. There's no medical records. And this is just an example as to how we as qualified medical evaluators are kept ignorant of the facts of the case. In this case, this is a new low for medical records. 0 pages of medical records is a new low. For a case for which we've received a cover letter. So this is a new low. So all of those findings are being held from us as the qualified medical evaluator, and this is just one example. And the principle behind today's discussion is that we as qualified medical evaluators have a very narrowed focus and a very narrowed interest in the overall perspective of the California workers' compensation system, which, if we were able to step back and be privy to more facts, to be privy to more information about the big picture of the claim and also of all claims in the state of California, it would help us better to understand not only the specific case that we're dealing with, but all cases that we deal with, so that we can understand the big picture principles, the big picture themes, the big picture scenarios, circumstances, and situations that govern the totality of claims in California's workers' compensation. And so in today's discussion, I want to bring you behind the scenes to let you see the bigger picture of what's operative and what's going on with your very next evaluation. So I want to share with you some brand new statistics from the Workers' Compensation Institute Review Board in their recent 2021 is brand new, publication, The State of the System, the State of the California Workers' Compensation System. So I want to share with you several things from these and another study, also by the WCRB. So we'll begin with some discussion about cumulative trauma injury claims, because CT claims are now abundant. Abundant or rampant or whatever you want, whatever adjective you want to use. These claims, there's a glut of cumulative trauma claims spilling out all of which will sooner or later require an evaluation by us as qualified medical evaluators. So it's critical that you be informed and up to speed on the world of cumulative trauma injury claims. So I have some fascinating things to share with you that are going to blow your mind about what is known about the who, what, when, where, why, and how of cumulative trauma injury claims. You're going to be amazed at what's actually known statistically throughout the state of California about these claims. Then we'll spend a little time talking about the frequency with which claims in California go on to involve a permanent disability rating, and I'll hold the punchline on that particular discussion until we get there. I'll share with you some interesting statistics about indemnity costs, and by indemnity costs, we're talking about costs related to death benefits, death related to permanent disability benefits, and benefits related to total temporary disability benefits. These are benefits designed to protect injured workers from losses, and so I'll share with you some of what's known about those indemnity costs in the state of California. And then we'll talk a little bit about medical costs in the workers' compensation system, and I'll share with you some little known secrets about the costs associated with medical legal evaluations, which is the work that we as qualified medical evaluators are engaged in. I have a couple of references for you today. The first one is a 2-year-old study from the WCIRB, the Workers' Compensation Institute Review Board, regarding the world of cumulative trauma injury claims. This is a fascinating study. I've included this in your handout materials for today's discussion, and you should spend whatever time it takes to read and reread this publication to be able to wrap your mind around the concept of cumulative trauma injury claims and how those claims are administered here in the state of California. And then also we have the brand new publication from the WCIRB entitled The State of the System, from which many of our references today come from this specific publication. So I have a fascinating discussion for you today. This is a discussion that's going to help you as a qualified medical evaluator to get out of the minutia of your case. You know, I speak to qualified medical evaluators all the time, and they very quickly get involved with the minutia, such as the range of motion of the shoulder in internal rotation compared to the range of motion of the shoulder in internal rotation of the other shoulder, and 2mm disc bulge on MRI, and all these minute details of the case, but don't really understand the big picture, the operative big picture, the operative situation, the operative circumstance, the operative scenario that's really driving the need for the evaluation in the first place. And so if we can get a handle on the big picture, it makes the resolution of these cases so much simpler, so much easier, so much less mentally taxing. If you can understand the big picture, you can quickly get to the issue in dispute and quickly resolve that disputed issue. So I have a fascinating discussion for you today as we continue with our ongoing series, and today we're discussing statistics, trends, and disturbing facts in California workers' compensation. Okay, so let's begin. Today we're discussing statistics, trends, and disturbing facts in California workers' compensation. And let's begin today's discussion with a review of some of what is known about cumulative trauma injury claims here in the state of California. Now, if you're a busy qualified medical evaluator, especially one with multiple offices so that you're seeing a certain volume of requests for evaluations, you are by now well familiar with claims that involve an allegation of cumulative trauma. And you know you're dealing with a cumulative trauma injury claim when there's a date range, a range being provided to you as the date of exposure, the dates of exposure for the cumulative trauma injury allegation. This is contrasted with specific injury claims, which involve only one singular specific date of injury. Cumulative trauma injury claims involve a date range, which is described as the period of exposure or the period of liability for that cumulative trauma injury claim. So let's begin with some statistics from the recent 2018 study from the WCIRB entitled The World of Cumulative Trauma Injury Claims, and I've included this for you in your handout materials. Now, according to this particular study, they tell us that cumulative trauma injury claim allegations, the rate of claims which involve an allegation of cumulative trauma injury, has grown 50% since 2008, and I'll show you how this looks on a graph. Now, interestingly, the vast majority of these cumulative trauma injury claims are concentrated geographically. They're concentrated to the Los Angeles Basin and San Diego County regions, which now generate approximately 75% of cumulative trauma injury claims, but only 50% of other claims, meaning only 50% of the specific injury claims come out of this area, this geographic area, but 75% of all CT claims statewide are emanating from this tiny, tiny geographic region in the Los Angeles and San Diego counties. Now, it's interesting, in the state of California, there are 58 named counties in the state of California, whereas the Los Angeles Basin consists only of 5 counties. There's Los Angeles County, there's Orange County, there's San Bernardino County, Ventura County, and Riverside counties. Only 5 counties, plus San Diego County, 6 counties. Now, these are large and population dense areas, but it's only these 6 counties out of 58 total counties in the state of California that are responsible for 75%, 3/4 of the cumulative trauma injury claims throughout the entire state of California. And you're going to know this to be true, and you'll recognize this phenomenon that 40% of these cumulative trauma injury claims are filed following the separation of the employee from the employer. Now, in our reference here, we use the word termination, but a better descriptor for an employee who no longer works for the employer would be separation. Termination seems to imply, at least in some of the cases that I've read, seems to imply that the separation of employee from employer was initiated by the employer, such as a firing or such as a layoff. Whereas the term separation is independent as to who initiated the separation. As you know, employees can initiate a separation from the employer by taking a voluntary layoff, by quitting, by taking a sabbatical. In other words, the separation of employee from employer can be initiated by either party, and 40% of all claims are filed after the employment relationship has ended. And you will know this to be operative in your evaluations when you see the cumulative trauma injury period coming up to and including the last date of employment. And then the application for adjudication of claim is filed weeks, months, even years after the last date of employment with ABC employer. And these are cases where the examinee will not begin medical treatment until, again, weeks, months, years, sometime greatly removed from the last day of employment with ABC employer. So you need to start to be able to recognize, number one, when you're getting a cumulative trauma injury claim, where that claim is coming from. Is it coming from Riverside County? Is it coming from Ventura County? Is it coming from these population dense areas? And then secondly, is this claim being filed post-employment after the employee is no longer working with the employer? Okay? So these are some things that you can start to quicken your thinking toward with your very next evaluation. that seems to involve an allegation of a cumulative trauma injury claim. Okay, so here is a graph that depicts some of the recent trends in cumulative trauma injury claims. And this is a graph that shows cumulative trauma injury claims by region within the state of California. So you can see here at the bottom of the graph in yellow is statistics relating to the entire state of California as a collective group, as a collective whole. And you can see that roughly since 2010 to now 2018, the rate of filing of cumulative trauma injury claims is relatively flat. And that's supposed to depict a flat line. Relatively flat with a recent slight increase from 2017 onward. But really, even now with preliminary statistics in 2019, the rate is really no higher than it has been throughout the last decade. In fact, in 2014 here, we had roughly about the same rate of filing of cumulative trauma injury claims. Now here in the Bay Area, as depicted in blue, you can see that the rate of filing of cumulative trauma injury claims is actually down, is actually decreasing over the past decade. Now contrast this with both San Diego and Los Angeles Basin counties, and we see here there's a dramatic upswing, dramatic increase in the rate of filing of cumulative trauma injury claims in these two counties. So what's fascinating about it is that in other counties statewide, the rate of filing of cumulative trauma injury claims is either level or is actually diminishing, such as here in the Bay Area. But these counties, these sections, these geographic regions within the state of California are showing a rapid increase in the filing of cumulative trauma injury claims. Now this increase here from say 11.5% to 15%, and here from 15% to 17% of all claims involving an allegation of cumulative trauma. Recall or take note that that increase involves thousands and thousands and thousands of additional cumulative trauma injury claims being filed in these 6 counties in the entire state of California. So you might ask yourself, what is unique about these 6 counties in the state of California? And if you're a qualified medical evaluator in the Los Angeles Basin or in the San Diego County, you need to be very, very familiar with the handling of cumulative trauma injury claims, because you're going to be seeing a glut of them. Now, while only 17% of all claims filed in these regions may involve an allegation of cumulative trauma injury, only 17%, right, 1 in 5, a little bit less than 1 in 5, it's these particular claims that have a great tendency to be denied claims, to be denied by the claims administrator as suspicious claims, as red flag claims. These are the types of claims likely to be denied by the claims administrator for which an evaluation from you is going to be required. So these cases in these areas, these are going to represent a large bulk of the evaluations that you're called upon to perform, for these very reasons, that these are the types of claims that have the greatest propensity and potential to wind up being denied claims as the claims administrator investigates industrial causation for these injury allegations. Okay, so specifically if you're in these areas of the state of California, including the Los Angeles Basin and San Diego counties, you need to be very, very familiar with the handling of these claims. Now, the reason that you're going to be seeing so many of these claims, particularly in the Los Angeles Basin and within San Diego counties, within this tiny geographic region within the entire state of California, has to do with a loophole regarding the date of injury for a cumulative trauma injury claim. So let's go over that so that you understand how it is and why it is that you're seeing so many cases now, especially in these concentrated regions in the state, so many cases that involve an allegation of cumulative trauma injury. And it has to do with the date of injury for these particular types of claims. Now, before we go into Labor Code 5412, let's just talk about the date of injury for a specific injury claim. The date of injury for a specific injury claim is a very specific date on which there can be no dispute. The date of injury for a specific injury is that date upon which the incident or occurrence happened, and from that date, the examinee has a 30-day time frame, a 30-day statute of limitation, to report that injury claim. Otherwise, the statute of limitation bars the forward progression of that specific injury claim. Well, cumulative trauma injury claims escape this statute of limitation, and it has to do with a loophole in the language that describes the date of injury for cumulative trauma injury claims. Now, this is described in Labor Code 5412. It's 5412 that gives us the legal definition of the date of injury for these claims. So 5412 tells us the date of injury in cases of occupational diseases or cumulative trauma, and we're mostly going to be dealing with cumulative trauma injuries if you're a neuromusculoskeletal evaluator. If you're an internal medicine or toxicology evaluator, you might be dealing with some of the occupational diseases. But most of us will be dealing with neuromusculoskeletal or psychiatric conditions that are representative of cumulative trauma. So the date of injury is that date upon which two things coincide, two variables, two circumstances, two situations have to intersect and coincide to establish the date of injury. Number one is that date upon which the employee first suffered disability therefrom. First suffered disability from the cumulative trauma injury. That's number one. And this date can be difficult to establish because it could be, if this case is filed post-employment, it could be that the employee never suffered compensable disability during the period of time of employment relationship. The examinee could have retired, never suffered disability, but later, a year later, file a claim for cumulative trauma injury for the period of time while the employee was employed. Okay? So this date can be difficult to determine whether or not there even was compensable disability. So there's one difficulty. The second difficulty in establishing the date of injury for cumulative trauma injury is that the other variable, the other component that contributes to the date of injury has to do with knowledge. Knowledge. So we have an employee who's suffering disability and then has to gain the knowledge, and he or she either knew or in the exercise of reasonable diligence should have known that such disability was caused by his present or prior employment. So imagine an employee who retires from work and then 1 year after retiring from work develops a cough, and the employee goes to his regular primary care physician for an examination, and the primary care physician, in establishing a history, asks the patient, "What type of work did you do?" And the patient confesses that he worked for 30 years in the coal mine. And the primary care physician diagnoses some lung disorder, some pulmonary constrictive disease, pulmonary restrictive disease. I'm not a pulmonologist, I'm making this up, but describes some pulmonary disease and makes the connection between the diagnosable condition and the workplace duties of 30 years in the coal mine. Well, it's at this point in time, 1 year post-employment, that the employee gains the knowledge that the cough was due to the workplace exposure. Okay? He had no cough, he had no knowledge. It wasn't until a year later that he suffered disability in the form of a need for medical treatment, and then at the same time gained the knowledge that the need for medical treatment, the disability, the need for medical treatment, was due to the workplace duties. And this date is now 1 year after the employment relationship has ended. So with cumulative trauma injury claims, a claim can be filed at any time post-employment if that date, any time, represents the first date that the employee gained the knowledge that the disability that they were suffering, meaning the need for medical treatment, was due to the workplace exposure. So this explains why so many cumulative trauma injury claims have increased recently over the last decade. It's due to this particular loophole that allows these cases to move forward. And as I said earlier, it's because of this very reason that the claims administrator has a propensity and a knee-jerk reflexive reaction to deny these claims, and then these claims then come to us for our medical determination. So these are some of the landmark dates and important dates that you're going to take a look at when it comes time to start preparing for your very next evaluation. You're going to want to start to be able to identify the species of claim. If it's a cumulative trauma injury claim, is it the particular species of cumulative trauma injury claim, the 40%? The 40% of those cases, is it the particular species involving the post-employment allegation of a cumulative trauma injury claim? Okay, so we know that all of the increase in the frequency of filing of cumulative trauma injury claims is coming from the Los Angeles and San Diego counties. So in these particular counties, who is it that's filing these claims for cumulative trauma injury? Well, that information is very well detailed in the 2019 WCIRB study entitled The World of Cumulative Trauma Injury Claims. According to the WCIRB, the recent CT claim growth is spread across many industries, and that makes sense, across many industries in these areas in Los Angeles and San Diego County. However, the manufacturing and hospitality sectors have experienced the most significant growth rates. So it's these particular industries, the manufacturing industry and the hospitality industry, such as hotel workers, such as amusement park workers, that are exploding with the filing of cumulative trauma injury claims. Now, even within these sectors, it's known that the growth is concentrated in lower wage workers. And a lower wage worker is a worker who is considered to have an average weekly wage, AWW, average weekly wage, below $500 per week. It seems that lower wage earners, those that are earning less than $500 per week, are filing cumulative trauma injury claims more than workers that have higher average weekly wages. So it's the lower wage workers that are filing these claims. And about 40% of the recent cumulative trauma injury claims, these are filed after the employee is terminated. In other words, after the employer has either laid off or fired the employee. 40% of the cumulative trauma injury claims are going to be coming to us as qualified medical evaluators as post-employment cumulative trauma injury claims. And if you're watching this discussion today, I know that at least 5 of your last 10 evaluations have involved post-employment cumulative trauma injury claims. If you'll take the effort, time, and inquiry during your face-to-face interview with your examinee, you can quickly determine that the employee is no longer working for the employer and that the claim has been filed long after the employee has separated his or her relationship with the employer. Now, of these post-employment cumulative trauma injury claims, about 3/4 of those are initially denied either in part or in whole, meaning that perhaps one of the body parts is accepted, where several of the claimed body parts are denied. So they're denied either in part or in whole, and about 1/4, the other quarter, also involve an accompanying specific injury claim. So if 40% of these claims, these post-employment, 40% of the cumulative trauma injury claims are filed post-employment, one quarter of them are filed within 1 year of the date of separation, of the date of termination, of the date of layoff, because the specific injury claim has a 1-year statute of limitations. So about one quarter of these, if they involve an allegation of a specific incident of injury, those have to be filed within 1 year from the date of the injury, the alleged date of injury. So these are claims filed within 1 year of the termination or separation. The other 3/4 can be filed at any point, at any point following the separation. And if there is no specific injury allegation, because the specific injury is barred by the statute of 1 year limitation, tells us that 3/4 of these claims are generally filed more than 1 year, after the separation of the employee from the employer. And here is a chart that depicts exactly that phenomenon. What we have here are the various industry sectors in the Los Angeles and San Diego counties, such as agriculture, construction, manufacturing, real estate, administrative services, hospitality, clerical, etc. And what this chart shows, and this is from the 2019 WCIRB study, is it shows the ratio of claims that are filed for cumulative trauma compared to specific injury claims. And for the manufacturing sector, you can see here that the cumulative trauma injury claims exceed claims filed for specific injury claims. And this chart, compared to a chart in 2008, this is the 2015 chart. When we compare this to a chart in 2008, there's tremendous growth here in this column, Similarly, in the hospitality industry, we see cumulative trauma injury claims actually exceeding specific injury claims as well, with a great increase in this quantity of claims comparing 2015 to 2018. Now, other sectors such as administrative services also exceed specific injury claims. Most of the others, we see that the specific injury claims exceed the cumulative trauma injury claims for most industries in the Los Angeles and San Diego counties. The rate of filing of cumulative trauma injury claims is either equal to specific injury claims or slightly is behind the filing of cumulative trauma injury claims. But in manufacturing and hospitality, both industries show recent increase in the filing of cumulative trauma injury claims. And we know that these particular industries have lower wage workers. Okay, so let's summarize some of this data. And if you're a qualified medical evaluator somewhere in the state of California, when it comes time to evaluating your next cumulative trauma injury claim, who is it that's going to be sitting across from you in the face-to-face evaluation as your examinee? Well, as we said, cumulative trauma injury claim growth in Southern California is concentrated disproportionately in the lower wage workers, those workers that have an average weekly wage of less than $500. So you're going to be sitting across a relatively low wage earner if you're in Southern California. Now, in San Diego County and in Los Angeles County, cumulative trauma injury claim rates have increased across all wage groups because Los Angeles and San Diego County is seeing an explosion across all industries and across all wage groups. However, most significantly, for the low wage income earner, the low average weekly wage earner, those with average weekly wages below $500. So I want you to think of the type of examinee that you could be evaluating at your next evaluation. It's typically going to involve a worker in manufacturing and or hospitality industries who are low average weekly wage earners, typically in the hotel industry, in the manufacturing and assembly industry. I've had recent examinees who are involved in assembling circuit boards, injured workers involved in assembling piping conduits for construction groups, etc. And so these are low average weekly wage earners. Now, in other regions of California, such as in Northern California, the largest ratios of CT claims are not in the lower wage workers, but in the higher wage workers, those with weekly wages of over $1,000. So this is $4,000 per month or greater income earners are filing cumulative trauma injury claims in other regions of California. So you might say this represents the white collar workers, whereas in Los Angeles and San Diego counties, we're sitting across from examinees in the face-to-face evaluation who are more the blue collar, what we would call blue collar types of workers. Now in Northern California, we're most likely going to be seeing a white collar worker for a cumulative trauma injury claim. But again, all wage groups outside of Los Angeles and San Diego counties, the rate of filing of cumulative trauma injury claims is declining. So your cumulative trauma business and your cumulative trauma evaluations outside of Los Angeles and San Diego County are going to be diminishing. And those, when you do get a case, it's likely that you're going to be dealing with a white collar worker outside of the blue collar industries of manufacturing and or hospitality. Okay? So these statistics give us great insight into the psychology of the examinee that we're going to be seeing in our very next evaluation that involves an allegation of cumulative trauma. So now, as we said, many of these claims for allegations involving cumulative trauma injury can be filed weeks, months, years, even decades after the employment relationship has ended. And California is very, very liberal in this regard. According to the WCIRB, California, among all states in the 50 United States, has a very slow pattern of claim reporting at 12 months. In other words, for this particular date of injury and time here, all of the claims that are going to be filed against this particular date of injury or this particular period of cumulative trauma exposure, only a small portion of those claims are even filed at the 1 year time period after the employment relationship has ended. Many, many, many are filed long after the employment relationship has ended. In California, the proportion of claims unreported at 12 months is almost twice the comparison state median, and I'll show you this to you on a chart here in just a moment. And the reason for that, as we said earlier, is because a large proportion of the late reported claims in California involve cumulative trauma injuries, many of which are filed following the employee's termination. So let's take a look at how California compares to some other states within the United States. So here is a graph that depicts California compared to some other states within the United States. States such as New Mexico, Texas, Arizona, etc. And you'll notice that across all states, approximately only 10% of claims are unreported at the 12-month period following the quote-unquote date of injury. But in California, the rate is nearly twice the median average across all 50 United States. So what this graph tells us is that in California, many more, thousands and thousands and thousands more claims compared to other states are filed after 12 months after the date of injury. And this has to do with that loophole in Labor Code 5412. So if you can understand this as a qualified medical evaluator, it helps you understand the big picture of the claim that you're evaluating. And many of these cases come to us as denied claims. So qualified medical evaluators such as you and I are getting this particular species of claim, the post-employment cumulative trauma injury claim, and many of those claims involve an allegation of cumulative trauma injury that is filed more than 12 months after the separation of employee from employer. So this gives us great insight into cumulative trauma injury claims, and particularly helps us to fashion our opinion on AOE, COE, industrial causation for these claims that come to us as otherwise denied claims. So let's shift gears a little bit and take a little look at some other statistics about California that have to do with your determination as a qualified medical evaluator involving the examinee's condition once that examinee's case has been accepted, and once that examinee has gone through medical treatment, and at the point in time when the examinee can be declared to be permanent and stationary. So let's take a look at how the medical decision making of us as qualified medical evaluators impacts the workers' compensation system as a whole. So according to the WCIRB, with regards to permanent disability statistics, in other words, of all those examinees or injured employees who come into the California workers' compensation system, California has by far, the highest permanent partial disability claim frequency in the country, approximately 2.5 times the countrywide median. This should say median. Okay? Now you might ask yourself, why is it that injured employees in California go on to receive a permanent disability rating at 2.5 times the rate of injured employees in Texas, of injured employees in Arkansas, of injured employees in New York? What is unique about California that leads so many injured employees to go on to require or receive a permanent disability rating? Well, according to the WCIRB, California's high frequency of permanent partial disability is not driven by industrial mix. It's not driven by the types of jobs that we have in California, making them so different from the types of jobs in Florida. It's not driven by the number of severe injuries in California. Injuries in California are no more severe than injuries in New Hampshire, than injuries in Colorado, than injuries in Wyoming, okay? Which are comparable, okay? Industrial mix and the severity of injuries are comparable to those from other lower frequency states. So you might ask yourself, what is it? What is it unique about California? And specifically, permanent disability claim frequency is significantly higher in the Los Angeles Basin area than in the rest of the state. So what is it unique about Los Angeles, first of all? And what is unique about California compared to the other 49 states that leads so many injured employees to go on and receive a permanent disability rating? And that is, it might have to do, perhaps, with the opinions and conclusions of California's qualified medical evaluators. And let's take a look at how this would appear graphically on a graph. So here is that chart that represents many states within the United States, such as Louisiana, Massachusetts, Texas, Georgia, etc. And you can see that across the United States, the median figure is that per 100,000 employees, injured employees, nationwide median approximately 256 out of 100,000 will go on to receive a permanent disability rating or award, permanent disability rating. Versus in California, that number is more than 2.5 times the national median, with approximately 639 injured employees per 100,000 injured employees going on to receive a permanent disability rating or award. And so you might ask yourself, what is unique about California? And it has to do with the opinions and conclusions of us as qualified medical evaluators, wherein in California, unlike other states, we feel compelled to find permanent impairment or permanent disability in our examinees, where the same examinee evaluated by a different evaluator in a different state within the United States, that different evaluator would opine for no permanent disability, whereas in California, our qualified medical evaluators seem to find permanent impairment and seem to opine on permanent impairment at more than 2.5 times the national median average. So this might cause you now as a qualified medical evaluator to take a hard look at your evaluations of your injured employees and take a hard look at your permanent impairment rating and particularly to assess your permanent impairment ratings for accuracy when faced with the knowledge that in any other state your particular examinee would likely be evaluated by another evaluator for 0% permanent impairment and no disability rating and or award. So very, very interesting statistics related to injured employees in the state of California. And now let's just finish up today's discussion with a couple of interesting statistics of relevance to us as qualified medical evaluators. Okay, so let's take a look now at some statistics related to indemnity benefits and take a look at the distribution of the indemnity benefits that are paid. Those benefits that are paid are distributed across a very finite number of categories, which provides for us some fascinating insight as to how monies are being spent on injured workers here in the state of California. So indemnity benefits are those non-medical treatment benefits. Those are the benefits that provide security or protection against a loss or other financial burden. And these are the other aspect of the workers' compensation benefits entitled to injured workers, separate and distinct from their medical treatment benefits. So according to the WCIRB, temporary disability and permanent partial disability, temporary disability, TD, standing for temporary disability, not total disability. Temporary disability and permanent partial disability comprise approximately 90% of indemnity benefits. And the share of indemnity benefits for permanent partial disability decreased over the last 5 years, as unlike most other types of indemnity benefits, there's no annual cost of living adjustments. So indemnity benefits spread across total, spread across temporary disability, and remember the law allows up to 2 years of temporary disability. So temporary disability before the examinee is declared to be permanent and stationary, and permanent partial disability benefits comprise 90% of all indemnity benefits. So let's take a look at this on a chart. Okay, so let's take a look at this in the form here of a pie chart, and I want you to focus your attention over here on this particular pie chart, which represents the distribution of paid indemnity benefits in the injury year 2020, of which there was approximately $3.7 billion of indemnity benefits paid. And of that, you can see that temporary disability here comprises the largest portion of those indemnity benefits at approximately 53% of all indemnity benefits paid are for temporary disability, temporary total disability, where the examinee is off work for up to 2-year period of time. And the temporary disability benefits actually exceed the permanent partial disability benefits here indicated in green at only 38% of the total benefits paid. So you might think that with your particular examinee, if your particular examinee has been off work on temporary disability, those temporary disability benefits may actually represent the bulk, the greater portion of their benefits that they have coming to them, because statewide and statistically across all claims, temporary disability benefits actually exceed permanent partial disability benefits. So if your opinion was that at the end of an extended temporary disability period, your examinee qualified for no or very little permanent impairment rating and therefore permanent disability benefits, that would be consistent with statewide statistics regarding the distribution of paid indemnity benefits. And then much smaller portions of benefits going toward permanent total disability here, those cases that represent 100 or complete 100% total disability, and then even a smaller portion representing those cases that involved death cases. So the greatest portion of indemnity benefits has to do with total temporary disability compared to permanent partial disability benefits. Okay, so that's very, very interesting for us to know, and it helps shape our opinions and conclusions regarding both the need for temporary disability and also the accuracy of our permanent impairment ratings. Now, let's take a look at some other interesting statistics related to the work that we, as qualified medical evaluators, are engaged in with every single evaluation. Okay, and then with regard to medical benefits paid in 2020 throughout the entire workers' compensation system in the state of California, you notice that the greatest portion of medical costs has to deal with physician costs. Physician costs accounting for approximately $1.1 billion of medical treatment rendered paid directly to physicians. Interestingly, for our purposes here in red, you'll notice that medical legal evaluations account for about 7% of all medical costs paid, to the tune of roughly $0.3 billion, or approximately $333 million of dollars paid to resolve disputed issues in the California workers' compensation system. This is the portion of the pie being driven and allocated toward our services as medical legal evaluators, whose job it is to resolve disputed issues within the system. So our market business, our ceiling, seems to be at approximately the $333 million a year annual business being directed toward us as qualified medical evaluators. Very, very fascinating statistics. So doctors, isn't that fascinating? Some of these statistics are facts and figures that we would never have any access to in the course of our routine work as qualified medical evaluators. But these statistics are important for us to understand as to how the bigger picture of claims are processed and evaluated in the state of California. In the state of California, if you're a current practicing qualified medical evaluator, you're going to be seeing a large volume of cases that involve an allegation of cumulative trauma injury. And of that group of cases, many of those cases are going to be cases that are filed greater than 12 months after separation of employee from employer. And this is going to open up a whole spectrum of issues for you as the qualified medical evaluator that will require your resolution as the qualified medical evaluator. Now, if you'd like more information about how to handle cumulative trauma injury claims and specifically post-employment, cumulative trauma injury claims, we have an entire 6-hour program entitled Cumulative Trauma and the QME, which will take you into great depth as to the nuts and bolts of actually resolving these disputed issues. For all of your claims across the spectrum, just realize that in the state of California, many of the examinees that you're going to be seeing are going to be concentrated in the blue-collar industries. They're going to be low-income wage earners who, whether they are evaluated by you or by some other evaluator, are going to go on at 2.5 times the frequency of any other state in the entire United States. They're going to go on to receive a permanent disability rating and or award from their evaluator. And very interesting. This might cause you to take a hard and close look at your particular determination with your very next evaluation. So doctors, I hope this helps you. I want to thank you for taking the time to join me on this week's discussion of statistics, trends, and disturbing facts in California workers' compensation. And for now, I'm wishing you best of success in your career as a qualified medical evaluator.